As somebody who's remained involved both as an advisor to the Markle Foundation and also doing some work here on these issues, is that nothing's gotten any easier in the intervening years, and we thought it was a big problem pre-9/11. It's obviously gotten to be even more so on that front in the post-9/11 environment, and also on the technology and sort of commercial side as well, with the proliferation of technologies, convergence, and all those interesting issues that keep members of Congress and people like Howard very active and involved. So there's a lot to talk about here. This program is part of the technology center or sub-center, however we call it, that as part of the Strauss Center that Ken Flam of the LBJ School is leading. It's a very important initiative for us. The Strauss Center is helping us look across a broad set of disciplines at some of the security, technology, and economic issues that are shaping a globalized world, and technology is obviously at the forefront of that. And here in Austin, we, I think, feel particularly connected to those issues. There's a very vibrant community here, and so I'm so pleased that a number of people from the local technology community are also with us as we look forward to engaging with all of you more closely in the coming years as we build up the Strauss Center and the collaboration across the campus, not only with the sort of the constituent schools that are part of the Strauss Center, but all of the colleges and units at UT. So I know this is going to be a fascinating and informative session and very lively, and so let me turn it over to Ken to get the festivities formally started.
My name is Ken Flam. I'm the director of the Technology, Innovation, and Global Security Program at the Strauss Center. Jim Lindsay, where is Jim? There he is. Man waving his hand in the back there is actually the director of the Strauss Center, which is a very interesting and important and hopefully useful organization on campus. The purpose of this panel today is to talk about Internet policy issues that are going to be confronted by the next administration, whomever that turns out to be. We have an excellent group of presenters today, as well as an excellent group of discussants. My job is to briefly introduce them and then sort of turn them loose on you. Let me just sort of briefly describe folks, more or less in alphabetical order. Marc Rotenberg is the executive director of EPIC, the Electronic Privacy Information Center. He also teaches information and privacy law at Georgetown University. He's the chair of the American Bar Association's Privacy Information Protection Committee. And I should also mention he's the 2007 Washington, D.C. chess champion. If anyone feels like making a dare or slapping a glove down or anything like that, he's the man. Howard Shelanski has the dual disadvantage or advantage, depending on your point of view, of having both a JD in law and a PhD in economics from Berkeley. From 1998 to 1999, he was a senior economist on the staff of the Council of Economic Advisors. From 1999 to 2000, he was chief economist at the Federal Communications Commission, and he's currently director of the Berkeley Center for Law and Technology. So I've asked Marc to talk about privacy and security issues, and I've asked Howard to talk about broadband policy for the next administration, which are two sort of key areas. They're more broad areas than actual distinct concrete issues. Both of them have a lot of complex and interesting things that are going on right now. Discussing this will be Ian Clark. Let's start in alphabetical order with Michael Braithwaite, who is the CTO and founder of NetStreams, an Austin-based company that does essentially IP-based streaming audio and video distribution technology. Michael's the inventor of a number of technologies and has patents in the area. I should mention Michael's also a former musician and composer and a continuing audiophile and music lover. And I look forward to Michael's reactions to the comments and presentations today. Ian Clark, at the end there, is a computer scientist and entrepreneur. He's the founder and coordinator of Freenet, which some of you may be familiar with, and which was the origin, basically, or predecessor of a distributed hash table-based data structure, for those of you into the techie details. But basically it's an anonymous peer-to-peer network that's played an important role in sort of free communications, I would say, on the internet. He's also the founder of Rever and Thoof, And so I welcome Ian to the panel today as well. And finally, Carolyn Purcell is the former Chief Executive Officer of the Texas Department of Information Resources and also the Chief Information Officer of the state of Texas. She's now a director in Cisco's state and local government practice within its global public sector business. So we have an outstanding panel of three very knowledgeable and distinguished Austin tech community members, as well as two outstanding presenters. I'm going to ask each of both Howard and Marc to present for approximately 25 minutes or some number thereabouts. And each of our discussants is going to respond with around 8 minutes, perhaps, of comments. So without further ado, I guess we'll kick off with Howard.
Thanks very much, Ken. It's a great pleasure to be here. I always enjoy coming to Austin, and it's a double pleasure to be able to be here and to talk about a topic that interests me and that I hope will interest some of you. I've titled my talk "Challenges for U.S. Broadband Policy: Competition, Investment, and Innovation." And the reason I've listed those things is that they are a real subset of the challenges confronting the next administration in broadband policy. I'm not going to talk at all about what may be the biggest challenge, which is privacy and security. I'm going to leave that to Marc. And you can't have a more expert presenter on that topic. Another topic that I'm not going to talk about, but which I think is one that will become more salient in the future, is the range of questions surrounding the issue of whether or not broadband communications and the Internet are good for us. There's starting to be some rethinking of this idea that more, better, faster, more widely distributed is always a good thing. But then again, the Internet is just a reflection of us, of all that is good and that is bad. And there are some real questions. Now, anyone who spends a lot of time in the classroom, as I do, certainly sees a lot of the downsides of the Internet. Students spend a heck of a lot of time, I suspect, chatting, bidding on eBay, working on their MySpace pages and all manner of other things, and I wonder how much antitrust law or whatever it is that I'm teaching that particular semester they're absorbing. That's a downside, but I'm not going to talk about that set of issues, and I'm only going to touch on another very big question, which is access to broadband communications throughout society. It's obviously a critically important issue. I know that a number of you in the room have worked on that issue. I'll try to touch on that in the end. Instead, I'm going to talk about the issues related to infrastructure and competition and investment and innovation in the Internet, because these are some of the regulatory issues that are currently front and center in Congress and at the Federal Communications Commission and indeed in the antitrust agencies. There are, broadly speaking, two sets of issues on which to address. Those that have to do with our changing approach to regulation in telecommunications, which affects broadband regulation. And then I want to talk about vertical relationships between networks and content providers, the debate that flies under the banner of network neutrality. So the horizontal competition issues and regulation, and then the vertical issues, network neutrality. So platforms are often how people talk about broadband. There are broadband platforms. And what we really mean by platforms are networks or alternative infrastructures for transporting and delivering communications. And these could be the traditional landline communications networks, your telephone, wireless networks, cable networks, satellite systems. There are other technologies that are out there like broadband over power line and things like this. These are all the possible platforms that may allow content and service providers to reach you in your home. And platforms have gone from being companions, living happily ever after for decades, each providing its own service to consumers. Telephone carriers provided you your basic telephone service. Wireless operators gave you a higher priced for a long time mobile service. We had cable selling video, satellite serving rural customers, and power lines providing power. They've gone from being companions to being competitors. As digital technology advances, the relationship among platforms has become a lot less harmonious. Telephone carriers want to offer video, wireless operators want more voice traffic, cable operators want telephone customers, and satellite operators are no longer satisfied with the rural market. And they all want to provide Internet access and online services. Convergence, that's the word that we often hear, And this increasing competition among platforms, what one might call intermodal, by which I mean telephone versus cable, different modes of communication, means that the different communications and information services consumers want are no longer tied to any particular kind of infrastructure. This is incredibly important, and most of you know this. Most of you probably have a device in your pocket that can serve your internet or broadband needs just as well as the network that serves your home. See, there's one right now. And so I'm probably being tracked by satellite, which is delivering content to somebody's personal communications device. And we see lots of different infrastructures carrying similar content. So convergence should mean increased competition and innovation. And according to the International Telecommunications Union, a next-generation network is a packet-based network able to provide services, including telecommunications services, and able to make use of multiple broadband quality of service, that's what stands for, QoS stands for, enabled transport technologies, and in which service-related functions are independent from underlying transport-related technologies. And it's very interesting if you I watch particularly the international students around Berkeley walk around talking into their laptops. They're talking, and they're not crazy at all. They're absolutely sane, and they're in fact smart consumers. What they're doing is talking on Skype, making free long-distance calls to their families around the world. This is what the ITU is talking about. They can make a voice telephone call independent from the traditional voice transport networks over their computer. They don't even know how it's ultimately traveling to its destination. And here's a very important point at the bottom. It offers unrestricted access by users to different service providers and supports generalized mobility, which will allow consistent, ubiquitous provision of services to users. Now, just to bracket the fact, there are enormous privacy and security issues here. Redundancy of this kind, multiple networks capable of carrying similar communications, are wonderful in the sense that if one network goes down or is damaged, you've got redundancy. But it also means that that's a heck of a lot you've got to monitor, a heck of a lot of places that content can be taken, stored. What are the rules governing that? How do you monitor that in cases where your privacy is invaded and you want to figure out who's got those pictures, who has that data? The ability to track, trace, and know where anything you have done resides becomes very difficult in this environment. I'm sure we'll hear more about that. So to meet the challenge of ensuring that alternative communications platforms respond by competing and by innovating rather than by consolidating and discriminating, we have some policy challenges. Good radio spectrum policies. Why good radio spectrum policies? Because there's a lot of unused spectrum out there, and radio technologies are some of the easier paths to market entry for broadband communications. Horizontal and vertical competition policy, antitrust policy, network neutrality issues, these are important. And I particularly note merger enforcement because I think this is something that has not been sufficiently heard, in my personal opinion, by the previous administration, and I hope that the next one, whichever it may be, will focus a little bit more on that. Okay, so what are the benefits of convergence and intermodal competition? As platforms increasingly compete to provide rival services, so too does consumer welfare as innovation increases and prices decrease. And the slides that follow will show some of the changes to the marketplace that occur as platforms compete and converge, trying to make this story much more concrete for you, using some fairly recent data from the US. Okay, so I have complete data up through 2005. And what are the transformations of the U.S. market? In 1996, we had 38 million wireless subscribers. In 2005, we had 185 million subscriptions. And this year, we just got the latest data, 240 million subscriptions. In 1996, incumbent local exchange carriers served 180 million lines. By 2005, that figure was below 140 million, and it has dropped another 20% since 2005. In 1996, only 19% of U.S. households had internet access. By 2005, nearly 75% had access. It's over 80 now in the latest data that just came out yesterday. But an interesting fact is that probably undercounts the significant number of people who have access not directly at home, but through their public library, through the E-rate program, or through work. And here's just a picture of what the changes look like. 1996 is blue, 2005 is red. And we really see wireless rising, wireline declining, and internet soaring. Okay, and this is really a battle of new versus old technologies. Wireless and internet-based communications are complements, but increasingly substitutes for conventional services. And in 1996, just for example, Americans placed 504 billion conventional local telephone calls and made an average of 143 minutes of long-distance calls per month. In 2003, Americans placed 425 billion conventional local calls and made an average of only 71 minutes of long-distance calls. And we see that highlighted fairly well here. The shorter bars are the more recent data showing a real decline of conventional telecommunications use. So where did the calls go? Well, the calls went to some of these new platforms. In 1996, the 38 million U.S. wireless customers used an average of 125 minutes per month. In 2005, the over 185 million subscribers used an average of 580 minutes per month. And the data that came out yesterday, 920 minutes per month. Now, I was trying to figure out how can you talk 920 minutes per month on your wireless phone? But I drive past a junior high school every day taking my son to school, and I understand, it's 7:45, and they're already talking. So that's where those minutes are. In 1996, is an interesting fact, fewer than 20 million U.S. households even had internet access, as we saw. By 2005, the three leading instant messaging services had 100 million distinct monthly users. The numbers are now much higher, and that's even putting aside email. That's just an indicative fact of the migration of how we communicate. So calls went from conventional telephony to wireless and internet-based alternatives. This is why broadband is so darn important. But the regulatory implications are substantial. Monopoly assumptions, the entire received framework for how we regulate communications, no longer hold. A priori rules that dictate that you, the incumbent monopolist, have such an advantage that you must allow new networks to have access to your network in order to enter the market, don't seem to hold when those other networks are of a completely different kind of infrastructure. You don't need to get access to the copper wires to provide communications. That's what the story is telling us. So we need to reconsider the whole scope of traditional regulation as we prepare for regulating in the broadband era. We need to reconsider retail price regulation. I'm not saying get rid of it. We need to rethink how we structure it and how we do it. We may need to get rid of it. Line of business limitations. That seems directly contrary to convergence. We have concrete evidence of convergence. Why would we keep rules in place that seem to go against the idea of convergence? And obligations to provide network facilities to competitors, the unbundling rules I referred to a moment ago. The problem is that as we keep this received framework of regulation, the framework that's in the 1934 Communications Act, but we don't have to go all the way back to 1934. It's in the 1934 Act as amended by the 1996 Act. The kinds of regulation, tariff filings, oversights, and presumptive obligations may lead to a situation where the regulatory benefits decline as competition increases. And just to note, the costs of regulation increase with competition. In the presence of competition, regulation may fail to send correct economic signals and, in the words of the FCC, may divert scarce resources from carriers that would otherwise use those resources to compete in local markets. Monopoly, on the other hand, gives regulators a large margin for error. Regulation can be imprecise and still be beneficial. Under competition, regulators have no such margin for error, and they may wind up deterring entry as well as reducing retail prices for consumers and entrenching old technology. Not a good line of policy. So a challenge for a future administration is sensibly to move away from those policies to a new set of policies that will acknowledge the convergence. And I would just note that we don't need perfect competition amongst networks. You're never going to get 100 networks. You're always going to have something that we economists would talk about as oligopoly, a fairly concentrated market. I won't go through the details now, but in a market with network infrastructure that requires high fixed investment and has very low marginal costs, the economics can lead to quite competitive behavior. And the basic intuition there is every customer you lose is lost revenue without reducing your costs. So you are losing pure profit every time a customer is stolen by a competitor. You have no ability to say, oh, I can proportionally reduce my costs now that I've lost that customer. You keep the same operating costs even while losing revenues. So there is enhanced incentive in this kind of marketplace to compete for every customer. So what's the new approach I recommend to competition in the broadband market? I'm not saying laissez-faire, complete laissez-faire, just let them go. It does imply that regulation through punishment of anti-competitive behavior ex post on a case-by-case basis would be more likely to create benefits and less likely to distort competition than conventional a priori rules. Now, this raises another very difficult problem for the future administration. We've had some antitrust rulings that may make antitrust law an inadequate, with the usual framework for ex post competition regulation, inadequate to the task. And I'm talking about the Trinco case, which basically says that we're going to have reduced enforcement of anti-monopolization rules under Section 2 of the Sherman Act, especially in regulated industries. So antitrust law may not be up to this task. We may just need a reformulation of what the FCC does. I would also say that competition enforcement among existing networks may not be enough. We may need market entry in new platforms. Spectrum policy is going to be essential to this. And we're seeing some very nice advances in spectrum policy. Still haven't got it quite right, but I think that the FCC has been doing, by and large, a very good job on rethinking how it allocates spectrum, how it assigns it to users, and how and the rules that govern the auctions. We're starting to see much more open and flexible auctioning rules and use of spectrum. And I think that this policy, which needs further development, is critical to new platforms and further broadband competition. Okay. So my conclusions on the horizontal competition aspects are that convergence amongst different communications platforms can help telecommunications markets become more competitive and innovative, as the evidence from the U.S. market shows. This competitive transformation undermines the rationale for our conventional framework for regulation, and we need a new framework which will emphasize ex post competition enforcement. And at the same time, we need to promote and preserve intermodal competition through, for example, sound interconnection policies and good spectrum and other policies. I want to shift gears now from the horizontal to the vertical and talk about network neutrality, because this is really one of the hottest issues in telecommunications. And the one plea I have is that as you listen to the candidates, as you read the op-eds, it is exceptionally important in this area to separate religion from science. This has really become an area on which people, sail forth and call their opponents awful names. I mean, look, if you want to look at current, the current primary battles, they're nothing compared to what goes on in conferences on network neutrality. I've seen people turn their backs, walk out of the room, and yet these are problems subject to inquiry through modes of analysis that we're trained in. Okay, so what is network neutrality? It's a debate over whether network owners, like cable companies, should be able to charge different content and service providers, like Google, different prices for different levels of network access. And network neutrality is the principle, in the words of Larry Lessig and his co-authors, all like internet content must be treated alike and move at the same speed over the network. The owners of the internet's wires cannot discriminate. This is an extremely radical proposition if you think about it. It means that your streaming video can be bumped for spam. Okay, you need to think about that. Okay, so this is not religion, this is science. We need to ask hard questions about whether this is a good idea. And each side makes some very strong claims here. Proponents argue that discriminatory access will chill innovation by applications providers at the edge of the network. If you have discriminatory access deals for different providers of content and services, some people will fold up their tents and not bother to innovate. We will get less interesting service over the internet. Opponents, on the other hand, argue that platform owners have no incentive to make internet less attractive to subscribers. It's Christopher Yu at the University of Pennsylvania is the main advocate of that point of view. On the other side, applications providers argue that discriminatory pricing will unfairly target deep pocket providers or providers that compete with the platform's own vertical service. Who would be number one there? Well, who's the deepest pocket provider on the internet? Google. Okay. Platform providers, on the other hand, argue that a ban on discrimination will impede investment in the core of the network. And successful applications providers free ride on the networks. They put tons of content on these networks, huge amounts of traffic, huge congestion problems, but they don't pay a penny, and all of the revenues that go to investing and expanding and building the internet capacity comes from us as end-user consumers. And they are saying that is the only place it should come. So again, when you think about network neutrality, you have to ask a hard question. Is that a good idea? Well, I want to ask a series of questions, and I would ask these to both sides of the debate. There's much we don't know. How much of a congestion problem really exists or is likely to arise? What is the extent to which discrimination would deter applications innovation, or how much would that deterrence really harm consumers? If there's one more person out there not selling something on the internet, the marginal value may be really small of that lost application. Who cares? How will regulation affect competition and innovation in the application markets? What is the extent to which platform owners fail to internalize complementary externalities? That's a long-winded way of saying, what is the extent to which the owner of a platform is really worried about losing customers if they block certain content and applications? How strong are their incentives to be transparent and neutral? Opponents of network neutrality say they have complete incentives to be transparent and neutral. I'm not so sure, as I'll explain in a minute. Should all platform costs be taken from end users and subscribers? Why is that necessarily a great idea? The owners of Google have some pretty nice airplanes. Should they pay a little bit for the infrastructure that's helping them buy those airplanes? Why should consumers, and those who are concerned about access and the distribution of access, you need to think seriously about this problem. What's funding the expansion and the upgrading quality of access? Should it always come from end users, consumers? It's a very small pool of revenues and subsidies compared to a lot of the applications providers that are making a huge amount of money. And then if we do allow discrimination, how would different pricing structures vary? And finally, where do the trade-offs lie between investment at the core and innovation at the edge of the network? These are really hard questions that lie at the heart of network neutrality, and it is shocking how often these questions are left out of the debate or cast aside as if they don't matter. I think what we can do in light of these questions is discard the absolutes. In light of what we don't know, the answers to those questions, none of the blunt arguments for and against network neutrality suffices to resolve the debate. Most of the arguments can be neither fully credited nor wholly rejected. I think we can discard the argument that applications providers are simply free riding on the platforms. If I'm a platform owner, people are not subscribing to say, hey, cool, I'm on a high-speed platform. They're subscribing to me because what they can get over my network. Maybe I'm free riding on Google. The free riding argument is not a self-evident argument for why network owners should be able to charge. But I think we can also discard the argument that advocates of network neutrality make, which is that investment in innovation in the core of the network, in speed and capacity, should be ignored because the real value of innovation is in all these garage tinkerers who are giving us amazing content. Yes, distributed innovation is a wonderful thing. You need investment at the core, and there's no better, and by the way, this is no longer a disputed quote. I have it on audio through Reuters. Google tried to run from it right after their person articulated it. The web infrastructure and even Google's infrastructure doesn't scale. It's not going to offer the quality of services that consumers expect. That is a statement that we need investment in the networks that carry content from these applications providers to your home. You can't simply get rid of it, and any network neutrality policy will inevitably involve trade-offs between this innovation at the edge by the content and service innovators and investment at the core. And I don't think it can be ignored. So we should base policy on uncertainty rather than on faith in extreme outcomes. And I would argue that network neutrality should be thought of as a problem of regulating under uncertainty. And we should recognize that there's some chance the discriminatory pricing that network neutrality advocates oppose will be harmful, and some chance it will be beneficial. On the other hand, network neutrality regulation itself may be harmful, and it may have net benefits. And I think we need to look at the probabilities of alternative regulatory outcomes and how they vary for different kinds of discriminatory conduct. And I just want to pose some actual regulatory frameworks that might be considered in the legislation and in the policies that go forward. The FCC may regulate in advance of legislation. For any of you who are following this debate, they just held elaborate hearings. And I think the chairman, Kevin Martin, is very eager to get some kind of statement out on network neutrality in advance of leaving office. He may want a statement disposing of the issue, but I don't know which way he will come out, but the FCC is likely to act. So a close look at the different kinds of conduct and regulation potentially at issue might reveal that we need not talk in the polarized terms of a complete ban on discrimination or complete non-regulation, which is unfortunately how the debate has proceeded. Okay, so what are the motivations and meanings of discrimination? I just want to talk quickly about two different kinds of discrimination that can be at stake here and to talk about what we're really worried about. Platforms might discriminate against traffic coming from applications providers because they have to. In this case, priority is offered because capacity limitations require some packets to be dropped at times. So discrimination equals priority when capacity constraints on the network become binding. Things are hitting the routers at the same time, and you can't put all the traffic through. You got to drop something. The question is, should we drop things randomly, or should there be some kind of negotiated policy about what gets dropped? And Ed Felton, the computer scientist at Princeton, calls this minimal discrimination. And the analogy I would use is that the fast lane is reserved, but only during rush hour. When things are too crowded, then we have discrimination in favor of fast lane. Unfortunately, platforms might discriminate because they can manipulate or shape traffic. Now, they can do this to help, as Comcast claims that it's doing, when it suddenly discovered a way not to do it, but they claimed they had to make their network flow better and not harm certain users. But they can also do it as a pure exercise of market power. We have the toll booth. If you want to get through to our customers, you pay us. It's unnecessary discrimination, and we could call this non-minimal or delayed discrimination. We will delay your packets even when we don't have to because we can, and you can't afford to have that delay, and you will pay us. That's bad discrimination. The other kind of discrimination, I would argue, is necessary, physically, technically necessary discrimination. And similarly, you can have different bases for who you discriminate against. You could do it randomly, or you could do it based as part of an anti-competitive strategy, or who you think is willing to pay, or who imposes the costs on your network. And this last one is what economists, I think, would favor. If there's one, I'll pick on streaming video for a minute, one application that's clogging your network, make them pay for that. So I would just say that different kinds of discrimination then pose very different kinds of risk. Necessary prioritization is of less concern than discretionary prioritization. Discrimination based on causation is of less concern and more efficient than that based on willingness to pay. This is a way of saying that not all discrimination is bad. Some discrimination can be quite good and quite useful. If we're talking about necessary discrimination because there is a blockage at the switch, do you really want your streaming video blocked and your spam to get through? No, you don't. Now, there are technical solutions to this. There's remote caching. There are a lot of things that one can do here to help to get around these problems. But I think we need to think seriously about whether congestion management could be a reasonable basis for discrimination. And so I have a simple taxonomy of discrimination: the good, the I don't know, and the ugly. Targeted pricing, that is to say, picking on a particular provider of content without a capacity, when you have a capacity constraint. I don't know how bad that is, but I certainly know that if I have a menu of prices for different levels of priority and I actually have capacity constraints in my network, I don't think there's anything wrong with that. It seems like a perfectly sound basis to let the people who most value speed pay for it. So I won't go through this chart in any detail in the interest of time, but I do want to say that the network neutrality picture and the effects of different forms of discrimination are sufficiently complex that pro or con network neutrality doesn't answer the question, and it's going to be a big challenge for the next administration, I think, to pick through the difficult details of this policy debate. So let me just conclude by saying network neutrality, I think, is a part of just a bigger broadband policy context. As I said earlier, spectrum policy and other means to enable a ubiquitous third platform, I think, are extremely important. The more horizontal competition you get, the less likely is vertical discrimination. Merger enforcement to keep the platform competition we have. No cable telephone company mergers, for example. I really think that should be an absolute rule, but it would evidently not be in the current administration, if I can express my own point of view based on certain recent decisions, the XM Sirius merger, for example. But I also think policy must be dynamic and be able to change as priorities and market structures change. So I think we've got a broad range of very difficult challenges here in the competition arena for the next administration, and any of the three candidates, whoever becomes president, I think will be addressing exactly the same questions. Thanks.
Thank you very much.
I appreciated Howard's story about the laptop dilemma. I teach at Georgetown Law School, and everybody brings in laptops. Never quite sure what they're doing, of course. And then I heard this funny story. I don't think it's true, but it goes something like this. A law professor was beginning his lecture, and he looked out on this large lecture hall and saw a student with a deck of playing cards, shuffling the cards and putting them out on the desk in front of him. And the law professor said to the student, "What are you doing back there?" And he said, "I forgot my laptop."
Well, Mark is setting up. I have to also remark we're setting off on refurbishing the LBJ School building. And I was interested to learn that one of the innovations is going to be wireless and jammers in classrooms to inhibit student use of laptops. And you think I'm kidding. I don't know if they've done that at Berkeley quite yet.
No, we haven't, but the University of Chicago Law School just implemented jammers. And there's actually been some question about the legality of the jammers up until very recently. So, yeah.
I'll tell a true story. A few years ago, I'm teaching a case, and everyone has their laptops out, and I'm heading towards some dramatic conclusion, and I say, and so Justice O'Connor reasonably concluded something, and someone who was actually reading the case on their laptop said, "Well, actually, Professor, she says in the next paragraph something that seems a bit contradictory to what you just said." And I said, "Could you please go back to playing solitaire? I mean, what else, really, it's completely unfair." So I wanted to begin by thanking Ken and Jim and the LBJ School and the Strauss Center for inviting me here today. I also wanted to recognize Gary Chapman, who's an old friend. Gary actually got me started in this field about 20 years ago. I was coming off Capitol Hill, and I was thinking maybe I should take a fancy law firm job, and Gary actually persuaded me to do something that was much less lucrative, so thank you for that. But it was an interesting time, and we were looking in the early days at the social impact of computer technology, of the Internet. I enjoy these conversations where people start measuring Internet time roughly when Facebook was announced. That's like time zero, apparently, for the creation of the Internet these days. But we go back a little bit further, I guess. So I'm going to talk about what I think is going to be a very interesting, very controversial, and I think probably also a very high-profile issue for the next administration. And that's the issue of privacy. I'm not quite as detailed as Howard is with respect to bullet points. I tend to focus on bumper stickers. So I'm going to be giving you a bumper sticker presentation. We have our own logo, in fact, for this issue, and that's our Privacy '08 campaign. It's nonpartisan. We're not backing any candidate. We just like the concept, and plus we downloaded this cool image and messed with it. So that's what I'm talking about. Now, why Privacy '08? Well, I only had so much space on this one slide, and I just wanted to hit the sort of the top level items, if you will. But there's a lot of reasons nowadays that I think people might be concerned about privacy issues in the United States. We had that wonderful program, Total Information Awareness, which you may recall was an effort to build these elaborate databases, link them all together, collect data that wasn't otherwise available, and kind of to merge it to predict all future terrorist acts. And this, by the way, was before Minority Report came out, which was, I thought, really was a remarkable insight. You may recall that they solved the privacy problem in Total Information Awareness by changing the name of the program. It became Terrorist Information Awareness. And when they made that announcement, we on the EPIC website appropriately said, name changed, problem solved. So that's one thing that people might be thinking about. They might be thinking about the Patriot Act, which is extraordinary law passed in the fall of 2001, reauthorized after, in fact, a very elaborate and extensive debate in Washington, not till the spring of 2006. It was actually set to expire in the fall of 2005, but there was quite a bit of debate over the sunset provisions. The domestic surveillance program, that's essentially the president's authority to look at who you're calling. I mean, do you call your folks enough? Apparently this is something the administration needs to know. They solved the privacy problems there also by renaming it. It's now the Terrorism Surveillance Program. We have Real ID, which is going to keep people in a number of states in the U.S. off of commercial airplanes after May 11th. Fusion centers, which I'll tell you a bit about in a moment. And the absence of any real progress on federal privacy laws over the last few years. So there are a lot of things happening out there. Now, in the Washington style of kind of reducing big, complicated issues around which, you know, PhDs will debate endlessly into the night into a few crisp sound bites, I'm going to break my presentation down into essentially 4 categories. Simmering debates, what the next president is going to confront when he or she enters the White House. What I call privacy foreign policy, because privacy is increasingly a global issue and has dimensions that implicate countries around the world. New initiatives, what we might imagine a proactive administration might do on the privacy front. And finally, next steps. So let's talk about a few simmering debates. One of the big ones, of course, is Real ID. Now, I respect this is not exactly an internet policy issue, but it does sort of deeply implicate new technology, and that this is an effort to establish a national identification system across the United States. It was, in fact, one of the recommendations of the 9/11 Commission, which looked at how it was possible for terrorists to take control of commercial aircraft and concluded that we did not have adequate identification systems in this country to prevent future acts of that type. And so there has been an effort over the last several years led by the Department of Homeland Security basically to upgrade the state driver's license in 2 respects. One is to make the document itself counterfeit-proof or tamper-proof, more difficult to falsify, which I should point out poses no problems in the privacy world. None of us want people on inkjet printers, you know, putting out driver's licenses that they can turn around the next day and pretend are real. But the problem with Real ID from the privacy perspective, of course, has been the goal of integrating government databases and making it possible, for example, that if you're stopped at an airline terminal or entering a federal office building, a courthouse, or by a police officer on the street, that will give the public official access to an enormous amount of personal information. And the remarkable thing about Real ID, and the reason that I think this issue has so much political lift, as people like to say, was the pushback from the states. because essentially we now have 36 states, I think, that have passed resolutions and said, in effect, they don't intend to implement Real ID. And even though the Department of Homeland Security played this little game recently with the states where they said, in effect, we will give you an extension on the condition that you agree to take some steps to implement, and most of the states said they would do that, I don't think anyone took it very seriously. So that is going to be a very big issue, and it will confront the next administration after the fall election. Issue that we're looking at, which I'm personally involved with right now, and kind of a follow-on to total information awareness, or state fusion centers, basically efforts to integrate local and federal and state databases typically operated by a law enforcement agency. One of the concerns we have in this area is the prospect that state privacy laws and open government laws might actually get rolled back as a condition of putting in place these new databases, which would otherwise be subject to state law. So we actually brought a suit a few weeks ago against the Virginia State Police, and I went down to Richmond and argued this open government case, and I was deposing the head of the Virginia State Police and basically trying to establish that they had participated with the federal government to roll back the state privacy laws. One thing I can tell you, having argued that case in Richmond against the Virginia State Police, I drove back on the highway just right at the speed limit. I didn't go 1 mile over. I was very careful driving back on the highway. But also, because we think it's a national problem, we decided on Friday, as I was getting ready to head down here today, to submit an open government request here in Texas. We're trying to understand what the impact of the Texas Fusion Center will be on state open government laws, privacy laws, and if I do any driving around Austin, I'll be careful as well. Okay, well, we're going to swing, I guess, into the internet space. One of the very interesting privacy issues that has literally exploded over the last year or two has been online advertising and behavioral targeting. And basically, this is the realization that internet companies have had, that the more they know about you, the more they can send you, just the right ad that will get you interested in some new product or pay some price. And a lot of very interesting, maybe Howard will look at this at some point, I think there's some very interesting economic issues surrounding behavioral targeting. The argument that's made by the proponents is that, of course, people would prefer to get advertising that reflects their interests rather than a lot of stuff that they're not interested in, and isn't it a good thing, basically, to put buyers and sellers together? And I'm sure, roughly speaking, that's true. But on the other side, of course, the more you know about consumers, the more easily you can manipulate them. I think also there's something called consumer rents. You might be able to determine a person's reservation price if you actually know what else they're looking at and what their interests are. A lot of very interesting long-term implications, I think, for this kind of one-to-one marketing that the Internet now enables. And that's something that I think the next administration will be looking at as well. Security breaches. Well, who would have thought that the Internet wasn't secure? I mean, I'm just surprised, amazed. But the number of calls and stories and, literally every day. My favorite, of course, well, there's so many to pick from, but the Department of Veterans Affairs, loses a laptop, 26.5 million American military personnel, personal records. That was actually number 2 on my favorite list. My favorite list included in the number 1 slot, at least for the last 6 or 7 weeks, has been the Transportation Security Agency. Now, this is the agency that's tasked with safeguarding planes, airports. This is like a front line of defense against terrorism. And also, of course, people make you take your shoes off. TSA lost on a hard drive the records of every single employee from February of 2002 to September of 2005. Roughly 100,000 individual personal information, bank account numbers, social security numbers, home addresses. Oh, and by the way, that also includes the air marshals, the guys who are supposed to fly secretly on the flights. All that information has apparently been lost too. So security breaches are a very big issue. I don't know exactly what the simple solution is. I do know that the California law which required notification and was triggered in a matter that we pursued against the company ChoicePoint a few years back, has helped make people aware of the extent of the problem. But what the solution will be on the security breach front, I think, is still a big question. Authority for the Federal Trade Commission. Well, unlike other countries, the United States actually doesn't have a federal level privacy agency like the FCC or the FTC. These, the FTC and the FCC are well established independent commissions. They have rulemaking authority. They have staff. They can conduct investigations. Most democratic countries in the world today actually have a similar agency or commission for privacy protection. We don't in the United States. So the FTC has kind of taken up the ball, and one of the big issues for the next administration will be how much authority to give the FTC. In the most recent authorization bill pending for the FTC, they get new staff, new authority, new fines. Privacy Act enforcement. Well, this is one of my favorites. I used to teach this in my privacy class, sort of like privacy history, 19th century, right to privacy, Brandeis, Privacy Act enforcement. The problem with that analogy is that the Privacy Act is current law. In fact, it's the most important law that protects personal information held by federal agencies, but it hasn't been enforced very much. So one of the big challenges, and this goes back to security breaches and some of the other problems we've had in the federal government, will be, will the next administration, say, for example, you lose a laptop, you pay civil fines, people go to jail. Could happen. Other privacy agencies. The President's Civil Liberties and Privacy Oversight Board. Well, the 9/11 Commission, which I mentioned just a moment ago, talked about the need to create new systems of identification, also said that to the extent that the federal government creates new powers of surveillance, it needs to create sort of counterbalance means of oversight, which makes a lot of sense if you think about it. Kind of mirrors checks and balances in the federal government. The key institution for the 9/11 Commission was the creation of a Civil Liberties and Privacy Oversight Board. The problem is that the Civil Liberties and Privacy Oversight Board that was established had, I think, 31 meetings, 30 of which were held in secret. So there's like no record of what they were doing. And they were meeting the entire time without making any recommendations, while this domestic surveillance program, without any judicial oversight, was going forward. Well, when Congress came back to take a look at this, they decided that there was going to be an overhaul. And we have now a new Civil Liberties and Privacy Oversight Board with new statutory authorities that's likely to have some impact on some of the presidential powers with respect to domestic surveillance. Okay, I'm going to talk a moment about privacy as foreign policy. Because increasingly, as I said, in our globalized economy, a lot of the decisions that are made in the United States impact other countries. Just to give you a couple of examples, take a large business like Google or AOL or Microsoft. They collect and use a lot of personal data on consumers. In many countries around the world, and particularly in the European Union, those business practices are regulated. Like a lot of other business practices. In the United States, we've typically taken a self-regulatory approach to a lot of the activities of Internet businesses, but there's a different view, really, within Europe. So one of the very big issues that's come up over the last couple of years is, will U.S. firms comply with European privacy laws? Recently, a group of privacy experts in Europe said, with respect to search engines, there have to be some limitations on how long personal data is being kept. Now, we've had a little bit of a self-regulatory PR campaign in the United States with companies like Google and Yahoo and Microsoft saying, well, they're concerned about privacy and, what you searched for last night, they're only going to keep for 2 years, which I don't think makes anyone feel particularly good. The European Privacy Commissioners said, well, 6 months is an outside limit, but even beyond the initial search, it's actually kind of an interesting question. Why exactly are search histories being kept? In other words, if the model is contextual advertising, and you say, for example, apartments Austin, you get a textual listing of popular websites, and then you get an advertising listing based on what people have bid for certain keywords. It's a very good business model because consumers are drawn to the platform by the editorial content, and advertisers are able to reach consumers based on their interest. No objection there whatsoever. Question is, why are the search histories being kept? Well, I think this is going to be part of the next administration's privacy foreign policy, because other governments are increasingly likely to say to U.S. business, you should not be keeping search histories. This is one of my favorites. Who knows what who is? Oh, whoa, savvy audience. Okay. Well, okay, so you register a domain, right? And the question is, the information that you provide to register a domain, who should that be provided to and under what terms? Now, the original thinking on who is was that this was really an administrative function. And if people were having problems with a particular site, there was an administrator there, somebody you could contact and say, I'm having some problems with your site, we've got a distributed denial of service attack or something else, can you tell me what's going on? Of course, over the years, who is has kind of evolved. And so now it's being used for law enforcement purposes, it's being used for copyright enforcement. And the interesting thing to me, without taking sort of a position on any of those policy goals, is just how far outside the mainstream the U.S. position seems to be. Because in most countries around the world, when it comes to who is, there are actually legal rules that limit public access to that data. And it's certainly true, for example, in a lot of the domains, the country code top-level domains, .ca, Canada, for example, .uk, England. There are legal restrictions in place that protect the privacy of people who register domain names. The U.S. has been so much opposed to that approach on who is that it actually prohibited, with respect to the .us domain, the use of proxy registration. In other words, registering a domain name and saying, I don't want my personal details available, but through a registrar, someone will be able to get that information. So that's going to be a big issue, I think, over the next year. Privacy issue, Olympics in China. China is building the most elaborate systems of surveillance in the world. In the Shenzhen province, as reported by Keith Bradshaw in the New York Times last year, they're integrating both biometrics containing genetic information and smart CCTV that recognizes people in public spaces, right? This is like next generation CCTV. So it's not just that you can record an image in a public space. It's that you can take templates or the images of faces, match them against templates, and go to a database and figure out who's in public spaces. Now, I mention this in the privacy context because there's obviously been a lot of discussion about China and human rights. I think at some point we're going to get to that discussion with respect to privacy and surveillance. Okay, new initiatives. What might the next administration do? Well, there's a lot of talk about a privacy bill of rights. And one of the remaining candidates, her name I won't mention, gave a speech a couple of years ago outlining actually a remarkable vision for privacy bill of rights in the United States. Included all the key elements of what most people might consider to be a good privacy law: opt-in for sensitive information, private right of action, a lot more transparency about the collection and use of personal data, and we'll see what happens with her initiative. Electronic health records. Well, you can't really talk about privacy in this campaign, I think, without talking about the very serious challenge that the United States faces as it tries to move health records to the online environment. There are a lot of studies that show that there are significant cost savings associated with the automation of health records, but there are also a lot of studies that show that if this is done poorly without adequate privacy protection, you may actually find people declining medical care because of the risk that their personal information won't be adequately protected. I think this is, in fact, going to be one of the very big issues in the fall campaign. Federal Privacy Agency, well, we can dream. It would be interesting, of course, if the United States were to establish a privacy agency. There would be more oversight of security breaches in the federal government. There'd be probably a bit more consumer protection. Whether or not that happens, I think, is still an open question. Well, this one I threw up here. Be interested if Howard has some thoughts. Epic over the last year pursued a fairly novel argument, but one that I feel pretty good about, and that is privacy and merger review. And we look specifically at the merger of Google and DoubleClick, and we said this was unlike previous merger reviews because the interests of consumers that were represented in the databases that were being joined as a consequence of this merger weren't actually being considered in the course of the merger review. In other words, the Federal Trade Commission was simply trying to understand, well, if I'm a web-based publisher and I have a choice between Google and DoubleClick and these two companies combine, what's the impact on the market? Are other competitors going to be able to enter the market? What happens to price? All the traditional stuff. Well, we said that when you're talking about Internet companies that are largely based on the profiles they have on Internet users, there has to be some consideration in the merger review of the privacy impact on individuals. And we actually pushed this argument quite aggressively. We did a whole series of pleadings at the Federal Trade Commission. I spoke in the European Parliament in Brussels earlier this year on this. With the FTC, we got basically one commissioner who agreed with us. We got one commissioner who voted for the merger but expressed a lot of concern about privacy. The Europeans felt that they could get to it in other ways. And then today, in the cover of the Financial Times, people were talking about the fact that a lot of the commitments that Google had made about privacy protection, which weren't backed up by any regulatory authority, during the time that the DoubleClick merger was under discussion, they'd actually seemed to have pulled back a bit from. So for us, one of the interesting issues going forward, I guess, for the next administration will be to what extent are you actually prepared to push the boundaries of traditional merger review to begin to think about the privacy impacts on consumers in this interactive environment when so much personal data can be collected. Privacy and de-identified data turns out to be a huge issue across many of these topics. TiVo, for example, they will say, well, no privacy issue here. All of our data is de-identified. The new GPS system, Dash, right? Very interesting GPS because it aggregates information from other users. Well, what's that? That's all the data on where the Dash users are at any particular time of day, particular geographic location. Aggregated, it's very useful. But if it can be identified, then it might have all sorts of privacy implications. Very big issue. Okay, next steps. Well, I'm just wrapping up here and tell you a little bit about Privacy 08. So we are nonpartisan. We have no candidate affiliation. On the other hand, we've had some very interesting meetings over the last several months with representatives of the Clinton, McCain, Obama, and Paul campaigns. Congressman Paul's representative began by telling us why we need to get rid of the IRS. Not much disagreement there. But if you are interested, we're now on Facebook. We've got a Privacy 08 page. Current information about privacy issues at epic.org and privacy.org. And this summer, you will see the Privacy 08 website launch with more information. So that's privacy in the next administration. Thank you.
Thank you very much.
Very interesting presentations. I'd like to thank both of you. I had a couple questions here that I had jotted down. And there was talk about the new line of business limitations and for the next administration. The big headline right now, of course, is the Comcast going through and very carefully positioning how they were selecting who they were discriminatory against, and even saying that it's not targeted towards them. However, the patterns of the data traffic that they were observing were, for the most part, only generated by the people that they were claiming not to target. And so basically, where do you see administrative policy or who to head up those types of issues?
So the question is really this. If we see your telephone company or your cable company discriminating against certain kinds of traffic that travels over the internet to you, the end user, who should be in charge of deciding whether or not those forms of discrimination are necessary or beneficial, or whether they're harmful and anti-competitive? This is subject of some enormous debate. Right now, there's dual jurisdiction. As a formal matter, you could go after that kind of behavior under the antitrust laws, as under some kind of monopolization or some kind of market foreclosure claim. And then it would be in the jurisdiction of the Federal Trade Commission or the Department of Justice. Or you could go through the Federal Communications Commission, which has broadly defined jurisdiction over the networks. I think right now there's a real debate about whether we should keep that dual jurisdiction or whether or not we should assign jurisdiction to one agency or the other, and what powers should we give them. My own sense is that the FCC is going to be the lead player here for some time to come. I actually don't think this depends on the results of the election. I should add that Senator McCain, if you read all of his announcements about antitrust enforcement, he's actually quite pro-enforcement, especially as compared with the current administration. There's not a lot of articulated difference among the candidates, although I believe there would be in practice. But there's been so little interest in aggressive application of the Sherman Act that the FCC has stepped into the breach, and any time we have actually seen an enforcement action, it's come from the Commission. And once you do one, you're sort of the go-to agency for the next. So I think it's going to be the FCC, and so I think actually one of the really important appointments for broadband policy going forward for this particular question is not so much the chairman of the Federal Trade Commission, not so much the head of the Antitrust Division, but who's going to be the head of the Federal Communications Commission. If it's Timothy Wu or Larry Lessig, you will find that all of that kind of behavior was ruled out. If it's one of a number of other people, I think you'll see the FCC taking jurisdiction and not enforcing terribly strictly.
Thank you.
So, Michael, I wonder if I could just follow up on that and ask you a question. So,
yes.
both Howard and Marc talked about issues that I would think would be of significant concern to a company that's talking about streaming various kinds of bits over the internet as your business model, both in terms of identifying where the bits are coming from and what they are, and also, as Howard just referred to, the rules of the road, so to speak, for charging for those bits. Is this an issue that you're concerned about?
It is.
Stay up nights?
And it's not. I don't stay up nights for that particular issue because it's what grabs the headlines, of course, is the peer-to-peer sharing type systems. But even though we're in that type of business, the big systems, the deployments that are going in right now are for the city of Boston, the state of New York court system, the state of Minnesota. The types of streaming data and material, the content, for a court system where they're recording, videotaping, and moving that data across the network looks like a peer-to-peer network traffic. And this is why when we talk about these types of issues, it would be easy to circumvent that if that's where they were looking. However, there are legitimate commercial reasons for that same type of traffic nature. And a court system is very, most people don't think of a court system as a peer-to-peer type network. But in cases where the defendants or the witnesses are in remote locations and that traffic is being delivered in real time into juries and judges, it is something that we're very interested in. And so
do I understand you correctly that you're not so concerned because your main customer base is sort of private intranets using IP technology and not the public internet per se?
Most of the deployments are on private networks. That is correct. But we still have to live with remote locations and so forth, and that's where when you go out, even out into the public realm through ISPs and then back into another one, that's where they then look at the traffic and the nature of the burst and the traffic flow looks like peer-to-peer. And so, does that help?
Yep, thank you. I just wanted to understand where you were coming from.
Okay, thank you.
Carolyn, I'm sorry.
Thank you. And thank you for the wonderful information. It was very well presented, and I really appreciate it. For me, the issue around broadband, and you alluded to it, of course, is the competition for bandwidth. It's all about bandwidth in the end in terms of the people that I do deal with on a daily basis, which are governments. And as that net neutrality issue will become increasingly important because there is such a scarcity of bandwidth. A little statistic, in Hong Kong, the incumbent there is now phasing out their 10 megabit per second service to the home because it simply isn't competitive. 25 megabits to the home is the least amount you can get now. And you can get a gig, 1 gig to your house. So this is the way the rest of the world, certainly not the rest of the world, but leaders in world economy are living in the kind of competition we have globally. We know in the U.S. that we are woefully behind. I think that the numbers from the OECD don't lie, that we really do have a scarcity of bandwidth here. What's happening is, I think, in the absence of a national policy around this issue, what we're seeing first and foremost are the larger cities who are going after this area to try to provide bandwidth to their constituents. This has not happened in very many places in the U.S., and it's happened in a variety of ways. And when you talk about innovation, I think this is one real crucible for innovation, is the way cities are approaching the issue of how to provide their customers, their citizens with adequate bandwidth. So I think that's an overarching issue that I would like to see the next administration help with. The states are now coming on board and trying to address the rural issue, which is really abysmal in most cases. Sometimes only dial-up if you can get that. I've been working in West Virginia with Governor Manchin on this issue, and these people are remote. And when we talk about the kind of kids you have in your classes, these children in these remote areas with no bandwidth, with dial-up service or nothing at all, will compete with kids that grow up in the Seattles and the Portlands and the San Franciscos that are working toward these tremendous bandwidths through fiber to the home mostly. So I think for me, it's certainly a big issue. And I would also say that this is not unrecognized by the service providers. I saw a snippet today from Jim Ciccone, yes, and I'm sure you know him well, who said that in 3 years, 20 typical households will generate more traffic than the entire internet today. So this is coming at us very rapidly. It's certainly approaching us quickly. With respect to privacy, I'm going to go back again to the issue around the millennials, and the millennials being those people that were born after after 1980 and up to 2000, and they're in the colleges now, and they're starting to infiltrate the workplace. And these kids, these young people, are certainly having an impact. They grew up, as some of us say, they are natives to the digital age. I'm an immigrant. I wasn't born here. So it's very natural to them. I don't think we can stop it. It's very interesting to me that the school that you mentioned that tried to actually prohibit, very interesting. I think these kids are more innovative than that. They'll figure out a way to get around it. But the other interesting thing about this population is that they are, to a certain extent, voluntarily abdicating their privacy. And this we see largely in things like YouTube and MyFace, and generally we can attribute this to their youthfulness. But I wonder, I certainly think that these kids are not like we were. I strongly believe in privacy also, and I think some of these issues, the Internet has a long memory. It doesn't really matter, I think, if you order somebody to eliminate a copy of data on the Internet. There's no way to know how many times it's been replicated out there, and whether the data is right or not is also an issue that we need to be concerned about, I think. And I think that's part of the Bill of Rights in Europe, is the ability to look at your own information and see if it's correct. So there are lots of issues there. Certainly 911 had an impact on the fusion centers, which I've worked with people when I was the CIO to think about how do you get aggressively analyze information to be as proactive as you can in saving people and keeping people safe. So you have both interesting challenges, and I think you both expressed your positions very, very well, and I appreciate that. And I hope we can all work together on this.
Well, I just wanted to pick up on kids and privacy, because I think it is one of the most interesting topics. There is a perception, of course, that kids nowadays, and particularly my children, put lots and lots of personal information online that they probably shouldn't. But I think if you look a little bit more closely, there's something else going on. Kids really do have a sense of control about the information that they choose to put online and about the people they choose to share it with. There's a real sense, who's on your I am list, who's not, who's a friend, who's not. These are the kinds of decisions that people have always made in the physical world that are now being made in the online world. And as the best evidence that they do care about privacy is the remarkable pushback that Facebook experienced when they changed the settings in Beacon. I mean, it's a remarkable thing, but they basically changed, the news feed from an opt-in to an opt-out, so suddenly everything you were doing was being broadcast to everybody, and there were remarkable stories. But Facebook actually faced a protest from over 700,000 users, your millennials, who I think felt that it wasn't fair that they were losing control over the disclosure. Now, I'll say something else about kids and privacy, and this is another area where Epic is spending quite a bit of time these days. We're constantly looking for innovative consumer privacy complaints, and I'd have to say, kind of genuinely concerned about the business model that sustains most social network sites, MySpace and Facebook in particular, because my quick take is that they represent to kids and to users pretty much what I just described. You decide, you control, you pick your friends, you put it up. It's your space, literally, to use as you wish. But there are a lot of things happening in the background that the users don't control. They don't control the data flow and the widgets. They don't control the advertising deals. They don't control decisions that are made about who to open up the network to and under what circumstances. So it seems to me that there's a kind of elaborate deception going on that kind of plays on people's desire to create trust in the online world, which is another way of saying privacy, but also find the commercial value, literally to monetize the user experience. And I think we're going to have to kind of confront that a little bit more directly than people have been willing to do so far. I don't think it's actually an absence of privacy. I think privacy is control. You know, privacy isn't being about, it's not sort of the life of the hermit. It's not like sitting in the corner, the lights turned off and the shades pulled down. I think it really is about your ability to move back and forth between public space and private space and to be able to set those boundaries yourself. And I think that's basically what kids nowadays, to the best of their ability, are trying to do.
Yeah, I mean, I think if I could just add quickly to two of the points. On the privacy point, I think that we don't know what kids are not participating out of privacy concerns. So there's always the counterfactual concern, and there's evidence that a lot of kids are not participating because they're not sure what's going to happen with what they post. The other side of it is that these companies are not going to be necessarily around forever. Like all brands, they'll eventually be replaced, supplanted, and managed down. And at the end of the day, they're going to be sitting on some very valuable assets of information. And there's nothing right now that controls what they do in the end game with those assets that are going to be the last thing they have to sell. And I think that's something we need to think about seriously. And then just the final thing is, I think Marc really hit the nail on the head. There's a certain layer that's transparent and another one that's incredibly murky. And I guess one of the things that I struggle with is whether we need a regulatory solution or not, but we need some kind of solution to making it transparent all the way to the end. Here is what happens with the network decisions beyond your decisions about who gets access to your page and whatnot. And just as to your point about broadband, just two very quick things. Korea, Hong Kong, all the places that are approaching a gig, we're never going to get there. We're never going to get there just because if any of you have been to Seoul, you get out at the airport, you drive over a bridge off of the island, and you drive past 10 million people every 20 minutes. And so building that infrastructure is dirt cheap. Same thing in Hong Kong. You do a drop-off of a main feed into some apartment buildings. You can't do that in Austin with the loop links. The costs right now are prohibitive. So it's going to be a combination of digital compression technology that continues to advance. And I agree with you, some kind of partnership. There are areas where it's not going to be done privately. But don't look for your gig or your 25 meg, frankly, in a ubiquitous way any too soon. And I'm not entirely convinced we need it right away, but we do need to be moving towards that. And that raises a couple of questions for the people who are advocates of things like net neutrality. Who's going to make that investment? And where the consumers follow, they don't lead. Okay, some consumers put a lot of bandwidth on the internet and will demand more. But it's really the applications that attract consumers that follow bandwidth. So we need to have the bandwidth to attract the applications to get the consumers to demand it. And so the problem is you can't go to consumers and say, I'll give you 100 meg if you double your price, because for most consumers, yep, there's nothing I need 100 meg for. And so they won't pay it. And so we're going to need a different model. It's going to be very tricky. And just as to the point about the courts that you made, it's fascinating. It does have to go out on the public internet. And the question you need to ask is, should courts be able to go to Comcast or whoever's running the public infrastructure and say, we can't be dropped? We can't have a witness disappear in the middle of a proceeding. It doesn't work for lots of reasons. The proceeding might have to be tossed out. You don't know if during the gap they're being coached. You don't know what's happening. This is very risky. Can we pay for priority to make sure that we don't get dropped? Well, yeah, that's a good reason. Okay. But then once you go down that road, you've moved away from the strict neutrality model, and I think the real battle is going to be, do these specialized uses warrant that or not?
Let's finally turn to Ian Corrick.
Well, thank you, Howard and Marc. I thought that was very, very interesting. As an entrepreneur, typically the only times I get involved with legislation or government is when it's about to do something that hurts me, such as when I got quite involved in the software patent debate in the EU. Typically when politicians have asked me or most entrepreneurs, how can we make your life easier? The conversation is always the same. First question is, can you give me money? If the answer to that's no. Second question is, can you crush my competitors? And if the answer to that is no, it's basically you can just leave me alone and I'll get along just fine without you. On the jumping to the net neutrality issue, this really makes my head spin. My background is as a software engineer, and but I have kind of formulated a couple of opinions on the subject, and I think what I heard today has helped me crystallize those a little bit. I think Howard's absolutely right that it's not a black and white issue, and it has become extremely polarized and political, and they hate each other, and that's ultimately not very helpful. I think the key question is that people, users of the internet, be it Google or be it consumers, need to pay for the resources they're consuming. If they're paying for the resources they're consuming, and that can be done in a fair way, then people will be incentivized to spend money on infrastructure such that they can shift more traffic from A to B and then get more money. So I think one question is, with the system at the moment, are people paying for the actual resources they consume? I think in many ways they are. Like the argument that Google, for example, is getting a free ride is rubbish. Google pays for bandwidth, and the more bandwidth they use, the more they have to pay. Additionally, consumers pay for bandwidth, although typically that's in the form of a flat rate. So I think the first kind of issue there is, are people paying for the bandwidth resources that they consume? If not, then there is an argument in favor there on behalf of the carriers to say, well, we need to be free to innovate here to ensure that people are paying for the resources they consume. I think that in the case of but at the same time, bandwidth must and should be a commodity. So if you're paying to get a megabyte of data from this location to this location at this speed, you really should be paying the same regardless of whether you're Google or whether you're a competitor of Comcast or whether you're whoever you are. You should be paying the same thing for the same service. And I think if we can achieve that, we should be able to minimize any kind of unnecessary, unfair discrimination that Howard alluded to. I think really the way I think about this whole issue, and again, my thoughts are not fully formed on it, the internet, or kind of the role of the creators and maintainers of the internet infrastructure, they're basically playing. They have the prisoner's dilemma, a game theory game where many of you are probably familiar with it. Briefly, for those that aren't, the idea of the prisoner's dilemma is you commit a crime with your friend, you both get caught, and the police separate you, and they pressure you to rat on your partner in crime, and the decision you're faced with is, well, either we can both stay quiet, in which case we might serve a little bit of jail time. I can rat on him, and if he stays quiet, I'll get off scot-free, and vice versa. Or we can rat on each other, and we'll both go to jail for a long time. And the problem with the prisoner's dilemma is that the best strategy is always to rat on the other guy. Because if you rat on the other guy, no matter what he does, the outcome for you is better. Now, this is basically the problem faced by the creators and maintainers of the internet infrastructure. And so the question is, how do you change the game so it's not a prisoner's dilemma, so that these guys are not incentivized to, some would say, abuse the control they have and try to, some would say, extort money out of companies like Google and others to the detriment of their own customers. And the mafia actually figured out a great solution to the prisoner's dilemma. What they do is they say, if you rat, we'll kill you. And that changes the nature of the game in a great way, because suddenly it becomes ratting is no longer the better strategy, and both prisoners will cooperate, and the outcome, even under this rather unpleasant threat, is then better for both of them. And I think that the potential is for the government to essentially fulfill the role of the mafia in this case and try to impose minimal, clearly defined regulations which which really keep the carriers honest, allow them to charge proportionately for the bandwidth that they're providing so that they're incentivized to improve their service, but not to abuse the control they have to the detriment of everyone, not to rat. Moving quickly on to Marc's talk about issues of privacy. I think a lot of this was about the question over government and what can government monitor and what can they not monitor, and how can we limit what government does in that regard. Just to make you all feel better, I heard a frightening story on NPR, I think it was this morning or the morning before, about the UK where I used to live, and people there they're much more tolerant of impingements on their personal privacy than people in this country. And I heard a story about how a couple went to secondary school. They wanted to get their kids into the secondary school. And one of the rules in the UK, as many other places, is that to get into a secondary school, you have to live within a certain radius. And they went there and they gave their information. And the council basically tracked them, monitored them using CCTV, the UK, of course, being by far the most monitored country in Western society, to verify that they actually lived where they said they did. Now, anywhere, certainly in the US, people would be horrified by that. Yet in the UK, people were kind of like, oh, well, I guess it kind of makes sense. So things could be a lot worse. We could be living in the UK. One of the big issues as a software engineer that I see with security and privacy is that a lot of, and we see this in terms of the TSA losing laptops and stuff like that, but really most security is absolutely rubbish. Like you have banks relying on things that are not secrets to protect access, such as your social security number. It is not a secret. You write it on probably 20 forms a year, at least. Yet banks rely on things that are clearly not secret in order to provide security to you. I think one of the perhaps easiest ways to improve all of our privacy is to somehow try to incentivize, perhaps through negative reinforcement, getting sued, for example, banks and other organizations, private organizations, to really impose good, robust privacy strategies. It's not a mystery how to do it right. There are well-established ways to do it right, which are almost universally ignored. And I think one perhaps role for government there is to try to poke and prod private industry to take privacy and security seriously, because they clearly don't do it at the moment. I've created businesses in the European Union in the UK, and so I've some experience as an end user of EU data protection laws, for example, and other privacy laws. And my experience of them, frankly, is that firstly, they're basically a welfare program for bureaucrats. And secondly, they're just farcical. And the reason is that they assume that Europe is this isolated island which doesn't have these transatlantic cables to other countries which have more liberal privacy laws than the EU does. And companies will generally just migrate to those countries, and it's just as easy for them to have customers in Europe, even if they're operating from the United States or elsewhere. So a lot of these EU regulations are well-meaning, but really just farcical in practice, and in some cases very, very expensive to implement. I'm not sure exactly what the answer there is, but I know at least one thing it isn't, and that's what the EU is doing today. I think one other. So behavioral targeting. My current affiliation. Things move quickly in the internet, and my current primary affiliation is a company called Uprisor Labs, and we're building collaborative filtering technology which can be used for behavioral targeting. So I kind of spend a lot of time thinking about this issue and thinking about talking to customers of this technology. And generally, when people ask me, well, hang on, isn't it scary that these companies have these information? Our technology works by building a model of a user's brain, quite literally a mathematical model of their brain, which we can then use to anticipate the response to things they haven't seen yet. It's kind of scary when you put it like that, so typically I don't, depending on the audience, but but really my response and my observations over the years has been that people don't object so much to what information you have about them. They object to what you do with it if you abuse it. Think about the amount of information that Google has in just with Gmail is unbelievable. They store incredible amounts of often very personal information, or bickering with girlfriends or wives, just incredibly personal information. Yet people aren't that worried about it because for the most part they trust Google. They trust that Google will not abuse this information. Facebook made this mistake. They demonstrated that they can't be trusted, that they don't really think these things through, and that they don't take privacy terribly seriously. So I think that is a problem. But I think focusing on preventing the information from being collected is probably the wrong place to impose limitations. If you're going to impose limitations, I think you need to focus on regulating usage of the information, because I think that's what people care about, and that's what offends them.
So Ian, could I just pause here and sort of ask if Howard and Mark want to respond to that? I'd also like to take just a couple questions, maybe just one more from you after that, and we'll throw it open to the audience.
Well,
Howard, Mark?
I was enjoying the game theory stuff because I actually spent some time studying that. And the other way that you basically promote cooperation is through the iterated prisoner's dilemma, so-called shadow of the future, which means to the extent that parties anticipate doing future bank jobs together and they get their lines down, they'll maintain cooperation. So that's another way to understand that. Of course, it's also a way when you're talking about business actors to describe collusion. So there's a whole other take on that as well. Well, let's see. As to the EU privacy rules and whether or not they work, I don't think the EU privacy people would describe this as a welfare program for bureaucrats. They have other welfare programs for bureaucrats, and the privacy rules by themselves aren't adding much to those programs. I will say the point that you make about the sort of the problem of enforcing privacy rules outside of jurisdiction, for that matter, enforcing any set of rules, is a really interesting challenge. But one of the things that people have observed about the European privacy rules, which is a little counterintuitive to the general understanding of globalization, and that is that, in fact, there's been a bit of a ratcheting up effect, which is rather than to simply expect, as most people say about globalization, investment in labor will flow to the land where there's the least amount of regulatory authority. In fact, what the European privacy rules have done is forced U.S. businesses to raise their game a bit, not only for the benefit of the European markets that they want to enter, but as a practical consequence for U.S. consumers as well. And that happened, for example, with the safe harbor arrangement in the end of the 1990s. This happened also with Eastern European countries when they joined the European Union as the new member states. They basically had to raise their privacy laws. So I agree with you. I think it's clearly imperfect, but it can help push things in the right direction. And it's interesting to observe that when it happens.
Howard?
Well, I guess the only point I would address is also one that Marc raised. I think the whole question of targeted behavioral advertising is a fascinating one. And I'm mulling over. I was very interested in Epic's brief on the Google DoubleClick matter and how privacy should factor in. And I have some thoughts about that. But let me just suggest one possible reason to be concerned about advertising based on your previously expressed and stored preferences. It may sound good. You now get advertising for things that you care more about. Your prices will also go up. And let me explain why. One of the earliest battles over the use of customer information through communications networks involved use by AT&T, a long-distance carrier, at the time, of the proprietary numbering information of Verizon's local customers. And AT&T had to have that because some of those local customers were using AT&T long distance. Well, by using that data to look into the customer records, AT&T was able to see if those customers were also subscribers to Verizon Wireless. This was incredibly valuable to AT&T because then instead of having a huge advertising budget where they just blasted advertisements to all kinds of people, they could target their advertisements to people who'd also already expressed a desire for wireless telephone service. They save money on advertising, but they're also targeting likely consumers. Who are likely consumers? Consumers willing to pay more. They're consumers who are higher up on the demand curve. So now when a company having access to expressed preference data is deciding how to price a good in advertising to the market, they don't have to price to the mean consumer, sort of trying to guess where on the demand curve consumers are. They can price directly to consumers whose preferences they already know. They know the demand curve better. So they will target consumers at a profit maximizing point higher on the demand curve, leaving out consumers who would have been willing to pay a profitable price for the good, profitable but not profit maximizing price for the good, and who will never see that lower price advertised in the market. So penetration pricing, all kinds of promotional pricing will move up the demand curve to consumers whose preferences are already expressed through all of the stored privacy information. It's a subtle possibility. It's an idea that just sort of came to me while listening to this, but I think it is a real reason that you might want to be concerned about having the market segmented by preference. The more you can target preferences, the more you can extract, as you put it, the consumer welfare, the consumer rents from particular consumers. You'll get a more segmented, higher price market. So I do think there's an interesting connection between the privacy issues and the more competitive economic issues that I think about. So I've got one idea to take home and work on.
Thank you. So let me throw it open now to the audience. Yes, so two questions visible.
I just want to talk a little bit, ask you all a little bit about behavioral targeting and marketing. But Howard, I'm Deborah Peel from Patient Privacy Rights. And I've got to tell you, what you're talking about that preferential use of data is absolutely what the drug companies are doing by stealing our prescription records, driving the prices skyrocketing high because they know exactly who's who. So, but I had two things I wanted to ask you all about. What is your opinion or what are your ideas about the use of behavioral targeting for politics? I'll never forget Ken Mellon saying, and we know who our voters are, and they are not the latte drinking, Volvo driving, yoga practicing, blah, blah, blah. So that's one thing. What about behavioral targeting in politics? And then the second thing that I wanted to bring up was looking forward about privacy. We think that the only area where Americans understand that they should have control of personal information is health, because of Hippocratic Oath, the long history of control we've had. And so we're really hoping, we really believe Americans really want to control their health information. And we think a lot of what's going on about privacy really is a need to control. And just like in health, in no other section of the flow of data are people very aware of where it goes. So transparency really isn't enough. Control is really essential because data goes to too many places that you will never, ever know about. And so, what do you see about the future for anything about Google buying 2 companies filled with your genetic records? How about that for an invasion of privacy? 23andMe and I forget the other. We'd love for you to break ground in that area. So.
Well, I'll just be brief on a couple of the key points. I mean, you asked about political campaigns, and that's a very timely, very interesting issue. And I actually spoke with someone who's doing an article on this, which I think will appear soon. And we both sort of came to the conclusion, I mean, the remarkable thing, of course, about advertising, whether it's for a product or for a president, is that you're basically trying to get a person to react in a certain way. There's no guarantee that the product will do what the seller says, nor is there a guarantee that the person running for office will do what he or she says. But what marketing is all about is to try to induce a response. So, I mean, you're exactly on track trying to get inside our minds, but you're doing... But this is my point, but you're doing absolutely nothing to assure us that the companies that will use these techniques will deliver on what it is that they're offering to us, which I think is a sort of a serious, kind of goes to the heart of what, you know, marketplace political determinations are about, and it gets real creepy real quickly. The other thing which I'll say on your second point, you know, there's a remarkable paradox about privacy. A lot of, you know, businesses and large I mean, this is like the one thing that, let's say, Google and the Department of Homeland Security have in common. They both are convinced that all of us have to get used to having less privacy because of the nature of new technology, because of the terrorist threat. I mean, you can insert whatever rationale you want, but obviously we all have to get used to less privacy. What's remarkable is that both of these organizations are extraordinarily secretive. It is very, very difficult. You know, PageRank, you will not find out how that operates, for example. Do you think they're doing street level on the Googleplex campus? I don't think so. I mean, the same thing with Homeland Security. Very secretive about all their internal practices, even as they're gathering all this data about the American population, which actually, in my mind, sort of points to kind of the key paradox about privacy. It's rarely the case that kind of everyone's privacy is diminished equally. I think what you see is that people, you know, in power and authority gain greater privacy or perhaps greater secrecy, and those who they exercise control over, again, I think the analogy works, find the amount of privacy, their ability to withhold information from others over time is diminished. None of this has anything to do with technology or modern society. It actually has a great deal to do with relations of power and authority. Foucault.
Howard? Exactly. The only point I would say is I think that the extent to which people are driven to insist on control as opposed to merely transparency will interlink with a number of other policies. I think the extent to which you insist over control over your medical records hinges a lot on healthcare policy. If we had Japanese-style healthcare policy where you could not be denied coverage for a pre-existing condition or for past use of medical services, you might be a lot less concerned about leakage of your medical records. With the healthcare policy that we have here, or kind of healthcare programs and our private insurance-driven model, you're desperately afraid of people finding certain things out. So I just think that it's one dimension of it.
There's a lot of conditions that are stigmatized and discriminatory that no one ever wants to know about.
That's obviously a huge dimension of it, sure.
Gentleman on the end here had a question. I think you're next.
I was going to ask, related to net neutrality, about the ideas of public infrastructure versus private monopolies or public-private partnerships and stuff. But in hearing some of the conversation, I figured that maybe more important would be to make a point, and that is, in thinking of policy, to be thinking way ahead. 2 weeks ago, I gave a presentation at the IEEE on the future of computing, and it was based on the PC and how far the PC has come in its 30 years. And in one way of looking at computing, as a futurist, there's all sorts of ways you can look at the future. One way is extrapolating past. Okay? In that extrapolating, which is it's actually it's not a straight line. So technology is evolving exponentially, but with the extrapolation, in 30 years, a personal computer device, if we were to have that, maybe a personal pen device or specifically, and this relates to privacy and why I brought it up, we're talking exabytes per person. Today, you can buy a PC with 3 or 4 hard disks, and each hard disk is a terabyte. And in 7 years, that's going to be petabytes, okay, per hard disk. Okay? So 30 years out, exabytes. And I'm asking the audience, what are we going to do with all of that capacity? And because we're surely going to fill up this stuff. And one example I used was that when I was at IBM, this was 10 years ago, we were promoting the concept of having a CMOS image camera sensor on your glasses that's recording on your wearable computer in high definition everything you hear and see throughout the day for your lifetime.
Distributed surveillance.
That's only a couple of petabytes.
That's one boring video, too. Sorry.
So what today might think of content is king becomes search is king. And how does the videos that are on YouTube, for example, if someone posts a video, how do you search and find that, or how are we going to tag it? Is it going to be tagged by frame with speech recognition?
Right, but if I may say, I think you need to think a little bit more creatively, or maybe I should say dystopically. It's an interesting question as we're generating all this data now and into the future. Who is going to control it? Who is going to control the digital representation of our physical selves? We're moving through a very interesting period of time right now. We suddenly have a crime called identity theft. In fact, for the last 5 years, it's been the #1 complaint of American consumers. Well, there was, fraud and forgery in the past. In some respects, that isn't new. But in other respects, Google clearly knows more, about me than I know about myself, because I could not, in my mind, reproduce everything that I've searched for. But Google could, right? And if you begin to think about exactly what you're describing, this enormous data trail that people are generating, that's not something that we necessarily control locally. In fact, everything is pushing it away from us. That's what cloud computing is about, is moving the data from the end user to the network. All the apps are online. All your mail is online. Well, if everything about you is out there, and there's more about you than you know about yourself, who's really in control of your identity? Who can more authoritatively represent your will, your desire? Who can be bound in a contract?
Just very little to add, except that, first of all, the technology to search by images, not tags on images like you do now on Google, but actually by images, is under development. And that's going to eat up an absolutely colossal amount of bandwidth once it's there. There used to be a crime, still is, called fraudulent impersonation. Now we have identity theft. So identity is separate from impersonation, if you think about it that way. And it's all moving, your identity is moving out to the cloud. The next step in this, and where a lot of those gigabytes, terabytes, exabytes are going to be used, is we're going to start locally caching, really locally, with the terabytes of data that we have here. And so I can download tons of stuff. I can have it run constantly. I can keep endless amounts of information updating in real time if I want through some kind of RF connection. Right there on my PC on some tiny little belt-sized device. So really what it's going to be is a double problem. It's going to be less control over your data and more distribution of your data, because more people can cheaply store it right there on themselves. Much harder to keep control and much harder to track. It's going to be a much more serious problem for Marc.
It will keep me employed.
Marc to solve for us.
Gentleman on the end there.
A few weeks ago, AT&T and Hollywood announced that they were going to get together and they could go through all of our internet correspondences for copyrighted materials. Have to go through all of this lady's medical records, but they could find it. And I said, well, hold it. They said, oh yeah, our new privacy policy allows us to do that. We've changed it, and you have no more privilege. It's now a business record, and we can work with whoever we want. And comment on that.
I was kind of like, most of what you put on the internet, if it's not encrypted, you're basically writing it. It's the equivalent of writing it on a postcard. Anyone along the route between you and wherever you're sending it can read it. So I would almost encourage end users to empower themselves through encryption technologies.
Are you going to encrypt in here on a daily basis?
So there are actual ways to address this issue and help with this issue, which are purely technological, that don't require any kind of government regulation.
Right, although it's tricky, Ian, and you're from the UK, so I'm surprised you didn't mention this. But of course, there's a big debate right now about a company called Form. And what Form is doing is extracting from the ISPs, actually in collaboration with the ISPs, data traffic to generate, targeted advertising. But they actually do a very good job protecting against the disclosure of personally identifiable information. They've really thought about the problem. It's a remarkable technology. In fact, in a lot of ways, from the privacy perspective, it seems almost ideal. There's no connection between the actual user's identity, but a highly targeted ad is generated. The problem with Form is that the data that it's using is the ISP traffic, which most everybody thinks is protected under various UK communication privacy laws. And the problem actually gets a bit more serious. If you think about it for a moment, this goes to your point. You've got technical standards for the internet, like, the IP security protocol, IPsec, which would go with IPv6. Really nice, give you end-to-end encryption, like, VPN, and you'd want that in place to help prevent, stop AT&T from doing those things. But if you've got Form out there with BT and the other UK ISPs basically telling all their customers, as a condition of getting ISP service in Britain, you're going to agree to this kind of targeting, and if you don't get ISP service, it basically kills at the front end all the technologies that could help protect privacy, which is why at the end of the day, I really do like technologies of privacy. I'm not just about regulation and big government, but I don't think you get good technology for privacy unless you have the legal infrastructure in place that pushes you toward those outcomes. In that respect, it actually looks a bit like, clean energy. You kind of have to create the market incentives to get the producers to do the privacy technologies. Otherwise, I don't think they happen.
Well, I think the technologies exist. We all probably use secure HTTP on a daily basis, and I think it's a question of making end users understand these technologies are available. We don't have to wait for IPv6. If we needed to, we'd be waiting indefinitely. But technologies like secure HTTP or secure POPs, there's secure versions of practically every protocol that we use today that you can use today if you choose to. So I think a lot of these problems can be helped by technology solutions like PGB, for example, or GNU PG. And you can get a long way towards solving or helping with these issues without falling back to government regulation.
We're getting towards the end. Let's just say two more quick questions. This gentleman here has been very patient.
Listening to you all talk a great deal about target marketing and building profiles. Is there any concern on a policy level somewhere that we're fundamentally building a nation of sheep? Those who are willing to sit back and be sought rather than a nation of seekers and investigators. I'm struck by the bombardment of target marketing, the bombardment of profiling. My comment is, I don't like it.
This just gets to the point that I opened my talk with, which is, I think there's some serious social questions to ask about all aspects of this. I would just say that I'm not sure we could become much more ovine than we were through the TV era. And at least a lot of what's going on here is the result of some more interactive forms of communication. So I'm not convinced that we're worse off as a result, but I do think that these are serious questions for behavioral psychologists, for sociologists, for everybody.
Lady in the end there.
One thing I have to say, the TV was not watching you back.
That's right. No, that's exactly right.
But I work with a lot of issues dealing with society, culture, and how people experience our new digital existence, and that there is a stratification, a human herding, where you have people who will push have a convergence of business and government in wanting to collect all kinds of data all the time. And then you have the masses of people that are on the bottom, at the lowest strata, who are maybe poor, vulnerable, who will fall into categories where it can be rationalized why they don't deserve the same level of sensibilities about privacy and civil liberties. It may be they are considered criminals or welfare fraud or people who are in the criminal justice system or even children who are under child protective services. We see an encroachment of wiping away the right of choice, even in public schools, collection of fingerprints. Basically, school lunch access. You know, I don't know, I never heard of why school lunch, which is so valuable, you need a fingerprint. But we see those kinds of rationalizations, RFID technology in school, identity badges, and so forth. I wanted to know, how does it fall into the matrix of transparency when you literally are seeing a generation of people raised in an environment where they are monitored all the time, and there's no identity with being free of that type of lack of transparency on their lives?
Well, what would concern me is if anybody, in order to obtain something that's an absolute necessity for existence, education, for example, was told that your education is conditional upon your signing away of certain privacy rights. I think, to me, that's an enormous level of concern. You talk about, it's easy to justify at a surface level fingerprinting to prevent fraud. That you're not getting your chit for school lunch and selling it to somebody or something like that. And that sounds good as a political soundbite, but what else is that fingerprint used for? How compartmentalized is it? When you move to middle school, is all that data destroyed? I think these are hard questions. And just, the final point I'd make about it is it gets right to the heart of whether or not you need regulation or market solutions. Market solutions there are always failures in market solutions. They may be efficient, they may do lots of things, but they tend to be less inclusive. And so if we just go back to the discussion we were just having about encryption technology, it may well be that there's an encryption technology that allows certain people, those who are sophisticated, those who have the resources, to obtain these technologies and prevent the kinds of hazards that are occurring. So the drawback to using technology is those people, felons re-entering society, all kinds of other people who might not have the knowledge, resources, sophistication, or access to take advantage of them would be protected by a regulatory solution and not by a market solution. So these are hard questions as we move forward, and I think what the work you're doing is very important to the question of whether we resort to efficient market solutions or we look at the social effects and move more broadly into regulatory solutions.
So I'm going to declare one very final, hopefully short question. I'm going to let one of our LBJ students, who's Mohammed Zafar, ask it, and then I want to thank everyone for.
One aspect we just talked about today is the cost aspect of all this. So we're talking about all the privacy, the net neutrality, the privacy of networks and computers and data and everything. But eventually, when you go about implementing any of these solutions, whatever policy solutions you come up with, is networks and companies and whoever owns different pieces of the network will have to incur costs. And the other challenge is these technologies change over time, meaning if these companies make this big investment and implement these technologies 10 years, 20 years from now, they will need to be upgraded again based on how technologies change. So what do you think this, I guess my question is how can we incorporate the cost into our discussions? Who should be paying for this and how can a market solution address the cost?
So Marc, who pays for privacy?
Well, good question. For a long period of time, privacy harms were difficult to measure, somewhat theoretical. I've written a few privacy laws. I do kind of a lawyer's trick, which is to include liquidated or stipulated damages. So someone, discloses your video rental tape in violation of the law, and we just say that's $2,500 in damages. It could have been $2,600, but we picked a number. What got interesting in the last few years is that it became possible to talk about privacy harms in more concrete terms. Because there began to be some fairly good estimations, for example, the cost of identity theft, or some of the causal costs associated with security breaches. Identity theft, according, I think, to the FTC in 2006 was approximately $53 billion. There's very interesting litigation right now in Massachusetts involving the TJX security breach of 42 million credit card records wrongfully disclosed. Now, what that means from the privacy perspective is basically an argument that some of those costs need to be internalized so that consumers don't end up, in effect, bearing the cost for someone else's bad practice. Now, if the consumer leaves his, wallet sitting in the back seat of his unlocked car and someone sees the wallet and plucks the $20, the bills out of the wallet, nobody says, oh my goodness, we need a law to protect people against their idiocy. That's not the argument. But if the consumer does everything right, here's my credit card, I sign what I'm supposed to sign, you give me the credit card back, and I protect it, and still, suffers some damage, then I think we need to find some ways to incorporate those costs. So, Howard, I imagine, might go a little different direction in terms of network development, but I would say on the privacy side, since we are beginning to see what the costs are for bad security, I think it will strengthen the arguments of people who say, listen, maybe we should, for example, routinely encrypt government laptops when they're removed from a government agency, because we know now what happens if an unencrypted laptop is obtained by someone else. We can make that, regulation.
I think we have to declare it to be the end of the evening. I want to thank all of you, and I want to thank our panelists for some very interesting presentations. Thank you for your patience and your interest. And we're going to have more of these going on over the course of the next year, starting in the fall. So thank you very much.